So good morning and welcome to another Community Legal Centres Queensland webinar. My name's James Farrell and I'll begin the session today by acknowledging the traditional owners of the lands on which we're gathered. Amy, Jennifer and I are at the CLC's Queensland office, so we acknowledge the Turrbal and the Yagara people, traditional custodians of the land that we now call Brisbane. But we've got people joining in from across Queensland, indeed from across Australia. This has been one of our more popular webinar topics ever, which is fantastic. So acknowledge First Australians across the entire country, pay respects to elders, ancestors, and welcome any Aboriginal and Torres Strait Islander people who have joined us this morning. The topic today, as I said, is really important and obviously a really attractive one to people working in community legal centres. We're looking at contravention proceedings in family law. Before I hand over to our expert presenters to go through the substance, I might just deal with a couple of housekeeping type things. We circulated a copy of this PowerPoint presentation by email in the last few minutes, so those that have registered should have a copy of that. You can also access that handout by press through the control panel on the GoToWebinar system there. In the handouts area, you should find the PowerPoint. There are a couple of ways that you can ask questions using this webinar. One is to press the button that looks like a hand on your control panel. We'll see something that looks like a hand going up at our end. We can unmute your microphone and you can ask a question. The easier way to ask questions, the second way though, is to type a question into the questions box on your control panel. We'll be able to read that here and we'll endeavour to paraphrase it or repeat it and get Amy or Jennifer to answer that. Hoping to have a recording of the webinar made available, technology allowing, so we'll circulate that when we can. And that's the housekeeping type things. So without any further ado, I might hand over to our presenters. Jennifer McArdle was admitted to practice in 1989, has worked primarily as a family lawyer for that whole period, including extensive stints at Legal Aid Queensland. She signed the bar roll in 2010 and has practiced exclusively in family law at the bar since then. Amy Honan has been is a senior associate and has been at Michael Lynch Family Lawyers for about 6 years, again practicing exclusively in family law areas. And so we're really grateful that Jennifer and Amy have joined us this morning to share their wisdom on contravention proceedings with workers and friends of community legal centres. I might hand over to Jen.
Hi everyone. I hope this will be an informative session for you. We've prepared the PowerPoint on the basis that it'll be a tool that you can use just to give you a heads up with some cases, but also some sections and the relevant rules for the procedures. So what we were going to do to try and make this as interactive as possible is to try and give you some examples of things and at the same time give you a bit of an overview about the law. Now, this is my first webinar, so if I get this wrong in terms of technology, James is here to help me, and I really want to emphasise to you all that Amy and I would really like to have questions in terms of our interaction. And I'll be frank, the easiest way for me to deal with them would be if you write them in and ask them at any time. If there's something in particular that we're talking about and you want to ask a question about that topic, do it as we go. Because we may forget about it if we wait till the end, okay? Okay, so I understand you've got the PowerPoints, so the most important part then is my funny heading, but we'll keep moving, some basics. It's a particular part of the Family Law Act that deals with contraventions in relation to children's matters. And what's really important and what we're going to focus on is working out whether an order's been contravened. That's going to be really important for us. And I've given you the section there. The second part of it is even though an order may have been contravened, that is not complied with, or no reasonable attempt has been made to comply with it, there might be a reasonable excuse as to why someone hasn't been complying with an order. Sometimes that can get a bit tricky. And we are going to talk you through some of the experiences we've had where people come and tell us that an order hasn't been complied with, and then we start to talk to them about the scenario and you start to hear what ultimately sounds like a reasonable excuse, despite the fact that the client who comes and sees you is pretty upset about the fact that the order's not being complied with. And it's really about what you do and what advice you give them about getting things back on track. On the previous PowerPoint, you'll see at the bottom, our advice is don't go there unless you have no other option. And that's really important because contraventions notoriously take forever to get listed. Nobody likes to run them. Nobody likes to hear them. That is, the judges don't like them either. And everybody tries to get out of having to run one, and everybody tries to settle them. Sometimes you can't, but we say if you can try and do all that preliminary work before you file anything, or if you get an application, your client gets an application, that you try and work out how you can settle it. The other thing I've put on that third slide is the standard of proof. So there is a standard of proof of balance of probabilities, meaning that it's most probable, essentially. But there's also, when you get to some serious breaches, there's a different standard, which is the higher standard that they use in the criminal proceedings. But most of the time, we're dealing with balance of probabilities. Okay, so the next slide that we have is drafting some orders, and this is where the fun starts. I picked these two examples, and I'm going to have Amy talk about some examples that she's seen about some orders that have been made. These were two that I did when I was responding to a contravention application. My client was alleged to have breached these two orders, and I've underlined what I think are the significant parts of where these orders have some problems. Because whilst we all provide advice to our clients and we all have drafted clauses similar to this, that phrase of any significant amount of time when a non-resident parent will be given the first opportunity to care for the child. So one parent can't care for a child for any significant amount of time. And there was never a definition about that, and there was never an agreement about that in the matter that I had. And the second one was, as I said, same matter. A second order was the child will communicate with a non-resident parent at all reasonable times by telephone, and both parents will facilitate this communication. Again, orders that sounded okay when I looked at them the first time. I thought, oh yeah, I know what that means. But then when I was on the receiving end of a contravention application, it all got a little bit hairy, and we needed to get down into the basics of the facts of the matter to work out what had actually been happening. Neither of those orders ultimately, in my view, would have been orders where a court would have necessarily said that a person may have contravened the orders without a whole lot more information around how did we get to a significant amount of time. In one example where it was alleged that my client was in breach of that first order that's up there, was that she had been away from the house for about, I think, 5 or 7 hours. Because she had some medical situation that had arisen and she needed to be away, had someone look after the child, and the applicant said that that was a significant amount of time, and in the end we were able to resolve a couple of those. Those two went away, but it highlighted to me how some of the orders that we draft from time to time are really, really important. Amy's got a few examples as well. She's had some interesting stuff. So I'm going to put her on and she can talk to you about some of the orders that she's had.
Firstly, I'd just like to say good morning to everybody out there in the World Wide Web. Hopefully you've got a cup of tea or a cup of coffee in front of you and enjoying that this morning, this early webinar. I just want to give some practical examples following on from Jennifer here in relation to the drafting of the orders. I was involved in a case in regards to 11 contraventions, and I'll only speak about 2 of them in this example, and I may raise the other ones later in the webinar. But these follow in regards to the drafting of the orders. The first contravention in regards to, well, the alleged contravention I should say, was the mother was having difficulty speaking to the children. This follows on from the example Jennifer has given about reasonable times by telephone and facilitating the communication. In the case I was involved with, the children were 12 and 14 at the time. They had an estranged relationship with the mother in that case, and the children were residing with the father. The mother had provided the children with telephone their own mobile phones or smartphones, and there had been evidence that on and off they would engage sometime with the mother and sometimes they wouldn't. In that case, the evidence was such that the children would sometimes communicate with the mother and sometimes not. And on that circumstances, the court wouldn't go so far to find that it had been the father not making the efforts to facilitate the children so communicating with their mother. So in that case, again, it's looking at, I guess, what the wording is there and trying to prove on the evidence there whether one person has intentionally not made those efforts to communicate. Following on with that one, there was also an example in regards to having to provide the children privacy when they were on the phone with the mother. In that case, again, it was quite difficult to prove that the children hadn't been given privacy in the circumstances where they could hear conversations in the background, but nothing there that the evidence there that the children was on speakerphone or things like that. So I guess it's just following on of those types of things about drafting the orders about what you want to have in place to affect the orders as such. I might put you on to Jen now, Jennifer, so she can talk about some cases.
Okay, on the next slide that you have, I've given you a couple of cases. One by Judge Altobelli, who's a Federal Circuit Court judge. That was a 2013 case of Seville and Seville. I'm not going to read it to you, but essentially what His Honour did was what we're going to talk about in a second. He started to get some understanding about the background of the matter as to how it was that the parties had ended up before him. And then there's one of Mendocino, I think I'm pronouncing that right, of Justice Forrest from the Family Court in Brisbane in 2015. And what His Honour said in that decision, which is important, is that it's not what both people might think an order means that determines what it means. It's the plain words used, construed in the context of all of the words, sentences and paragraphs contained within the same primary order that determine the meaning of the order. Those cases are really easy to find. If you're on Austlii, you just punch in those names. They'll come up very quickly for you. But I've given you those references because both of the judges in those two cases dealing with contravention applications give you an understanding about how a court would look at a contravention application. And it is a technical process. So we're going to get into that now in the next slide. The first thing when a client comes in to see you is to read the order. Okay, so if you've got an appointment with someone and you have an opportunity to have a chat with them or have someone have a chat with them before they come and see you, whether it's the person who makes the booking, whether it's via an email and someone sends in a request for some assistance, the thing you're going to have to get from them is a copy of the actual order that they say isn't being complied with. And then you're going to have to read it very carefully and then read it again and again and again. And you're going to read it multiple times in either the preparation of any material that you might be filing because your client wants to file a contravention application, or if you receive a contravention application, so your client's the respondent, you're going to need not only the application but also the order, which should be attached to the application in any event, and you're going to keep going back and reading them time after time after time. The thing you're looking for is it really enforceable? Is it something that a court is going to say, yes, that people should have been complying with that order because it's an order that on its plain reading and understanding, we all know what the obligations are, and under the Family Law Act, each of the parties has to comply with their general obligations of compliance with orders. Okay. Now, the relevant section in terms of the starting point for contravention applications is Section 70 NAC, and you can find that in the Family Law Act yourselves. But essentially, I've written down what it means for someone to be taken to have contravened an order, and I've put it there for you in basic terms. But these sections are a little bit complex. The process that you undergo with a contravention application is also quite a complex process. In a lot of ways it's simple, but in a lot of ways it's actually quite difficult. There are rules in relation to what happens with the contravention application, and I'll take you to them later in the slides, but you need to make sure that when you're taking instructions and you're giving advice, that you have an understanding about the whole process, from the beginning to the very end, okay? So you start with looking at assuming that the client's come in saying he or she, that is the other person, isn't complying with the orders and I want to make them comply. That's a fairly common statement by a client, and one no doubt you have all heard time and time again. I know I have. But then you have to calm them down a little bit, and then you have to work out what is it that they actually want in terms of an outcome. So when you sit down with a client, I say to you that it's not about pulling everything together. That's why I've given you the penguins in terms of the cartoon there. They all look in different directions. They all have different jobs to do. It sounds like or looks like it's going to be a really complex situation, but somebody has to take control, and it's you, in my view, as the lawyer. If and when, and I know that that's difficult for you guys with the CLCs, but if in fact you have a barrister who is able to be engaged, if you've got some serious matters coming on, and I know that your funds are very limited, but there is a pro bono scheme, and I do know that from time to time there are some barristers who are more than willing to help out in some very complex matters. Most counsel, and I think most solicitors in private practice, if you have some connection with them, would be more than willing to take a call to just talk through what the problem is. I know I would be, and I know that there are many counsel who I know who do family law who would also be more than willing to take a call, okay? So the first thing you need to do is when the client comes in is calm them down a little bit. Take control. You need a plan. You need to get complete instructions, not just the ones that your client wants to give you, okay? This is not just about a one-sided story, because what can happen when you go before a judge, and it happens to all of us, is that if you don't think through what the case against you is going to be before you start your process, you can bet that your material may not cover all of the things you need to cover if you don't actually get the complete story. So I can't emphasise that enough to you. Take the time to understand what on earth is going on with these people. And a really good example of that was in a matter that Justice Murphy did. He's a family court judge in Brisbane, in a matter of Wright and Adams No. 2. It's a 2002 case. It's a fascinating case because both parties were in person. And His Honour, and if anyone's appeared before His Honour, you'll know that he wanted to try to mediate the problem a little bit, to try and see if he could sort out what the problem was, because these two people had both filed, it seems, contravention applications against each other. And if he said the sky was blue, she would say it was black, and it didn't matter what. So their contravention applications were run, and you'll see from what His Honour had said to them that despite his best endeavours, they were going to run their applications, and they have every right to run their applications, and he heard them. They were all knocked out, essentially, one after the other. But essentially what was the problem with these two people is that they couldn't communicate. They wouldn't communicate, and they wouldn't be helpful to each other, okay? So that's an interesting read in terms of how a judge dealt with some litigants in person, and it's just fascinating to see what sort of contravention applications were being made. The mother in that one in particular, I'll give you one example. The father had clearly not had a telephone communication call with the children, and she contravened him on the basis that he didn't make a 45-minute call to the children as compensation for the 45 minutes that they were unable to have a conversation with him. His Honour didn't actually understand that the order had made had put an obligation on the father to do that, which was where she fell apart. But it was an example, clearly, of how these two just couldn't communicate with each other. Okay, so looking at the order, and you'll see it time and time again, look at what the order says, see if it actually makes sense, and ask in full whether or not it's been complied with. Also ask if your client has been complying with the order that he or she says the other party isn't complying with. That's a cracker. I don't know how many cases I've had where, in fact, the client comes in saying the other party hasn't actually complied with the order, but when you start working through the facts of the matter since the order was made, your client hasn't either. And we all know what happens when the judges get wind of those things. You don't go pointing the finger at somebody. So, and I understand Amy's got some examples of something like that too, so I'm going to hand it over to her.
I think so, just to follow on from Jennifer there in regards to reading the order, I'm probably going to bang on just like Jennifer has about how important that was. One of the earlier cases that Jennifer referred to, and I'm going to pronounce it wrong as well, the Mitakono case, which was one where there was a dispute about when school holiday time would commence, and so one party was reading one section of the order and the other was relying on another part of the order. So it's really important to read the order in its entirety, as you may have some kind of orders that have exceptions in regards to school holiday or special occasions or those types of things. It's talking about obviously the importance of having or complying with the order as well, and our obligations as solicitors to advise them of their obligations under the orders in regards to complying with them. I had a client who had children that didn't want to, again the same case that I was referring to previously, had children that didn't want to get on the plane and go visit their mother on the other side of Australia. In that case, the client had telephoned me up and advised me that this is the kind of comments that he was getting from the children, but I advised him about his obligations on the orders, and he took my advice and took steps which included going to speak to the social worker that had previously been involved with the matter to talk them through about going on the plane. He checked the children in with their airline tickets, and he took them out to the airport and even tried to board them on the plane. He asked the Qantas staff as well to assist him with putting the children on the plane, and ultimately they did not get on, and the mother brought the contravention application. In that case, my client was able to successfully argue a reasonable excuse for not complying with the orders because he had taken those steps to try and comply with his obligations on the order for the children to spend time with the mother. So I think it would be a completely different case though if in the circumstances the client hadn't taken my advice and tried to at least comply with the orders, even if he had a 12 and a 14-year-old who were quite strong-willed in that case, who said they didn't want to go. He still did all things necessary to try and comply with the orders. And I think that's important if you do have a client coming in with advice and they've brought in a copy of the orders and they're saying little Johnny doesn't want to go and spend time with mum or dad, that you talk through with the client their obligations under the orders and what steps they can take to try and comply with the orders, that if they are contravened, they'll have a reasonable excuse for not complying. Another example of one that I can relate you to is in regards to another case that my colleague had where the mother in that case had suspended the time because that was advised by the child therapist at the time. At that case, the father brought a contravention application because his time had been suspended. Ultimately, she was able to argue a reasonable excuse, but the judge was really quite critical that she hadn't undertaken any steps to put in place some further treatment for the child so that the time could recommence with the father. And ultimately there was a couple of counts in that one, and she was able to do reasonable excuse in one, but in the other one she was put on a good behaviour bond for a year. So I think it's about when you've got a client coming in thinking about our obligations as solicitors and legal representatives about advising the clients about their obligations under the order. I'll just put Jennifer back on.
Okay, so now that we've hammered you all repeatedly about reading the orders, we'll move on. Assume that it's clear, the orders are clear, that the drafting was very good, and your client has provided you with information which says that there's nothing that says they are not complying with the orders, but that there has been a non-compliance by the other side. And this will be most of the people, I would suspect, come in and see you guys. So the next thing you need to do is find out from them, and you're looking at a different aspect of it now. You're looking at whether the case you would have to meet in terms of a contravention gives rise to a conclusion that the respondent had a reasonable excuse. Okay, so it's important that you're looking at that, and it's important that you also obtain from your clients an understanding about what outcome do they want. I have never had a matter where I have actually had someone in court say, I want the other person jailed. Now, I'm sure people probably think that, and I'm sure that you guys have probably had some people come in and tell you that, but nobody says it in the courtroom, despite what they might say outside. And of course, that's an ultimate punishment, and we've certainly had some judges who've done that. We've got one in Brisbane who tends to do it a little bit, and doesn't always successfully have that sustained on appeal. So it's certainly one of the options, but you really need to work out what it is that is actually the problem, rather than people coming in saying, he's breaching the orders or she's breaching the orders and I want them punished. One of the other things I've put on the slide that I hope is still in front of you, that it's still at the beginning, is to try and make sure that you're getting instructions from your client and not the person who necessarily is there with them. I know that can be very difficult because sometimes it's not your client or it's not the party to the order who's driving the process, it's somebody else. So you really need to be clear about that, and it can be very difficult to do that. We've all had those scenarios. So looking at what's a reasonable excuse, though, I think is important, and that's the next slide, and I've given you the section reference that deals with reasonable excuse. Now, it's not just limited to the things that I think become a bit of a fail-safe for most of us when we have clients come in. That's about health and safety, because they seem to be the easy ones in the sense of you can probably get some independent information about that. It's not limited to that. That's why you have to sit down with your client and work through, well, why wasn't the order complied with? I've given you a reference on the next slide, I hope, which is about reading the application or drafting the application. There's a couple of cases at the bottom there. One of them is a matter of Stubbs and Stubbs, which was a 2013 case by Justice Dorr, and she talks about reasonable excuse. And what Her Honour was actually also trying to address was not only the subjective elements of that aspect of it, but the objective elements of it, so that you turn your mind to both. Your client might have a reasonable belief in something, but it may not be based on reasonable grounds, essentially. So you're looking for, if a client comes to you who is on the receiving end of an application, or even a threatening letter saying they're about to file an application for contravention, and you want to give them some advice, work out what it is they say caused them to act in such a way that an order wasn't complied with, because there can be lots of reasons why it wouldn't be. You'll also need to then follow up and try and get some evidence to back it up. That is something that will tell you what happened. Good luck getting something out of docs, has been my experience. Occasionally, back in the day, and I've been doing this stuff a long time, they would write these nice letters saying that they're investigating something to one parent that could in fact be used as a reasonable excuse or a piece of evidence about reasonable excuse. I haven't seen one of those in a long time, and I don't know if anyone else has either, but they certainly used to write them. The other, of course, is some medical evidence if there's a significant issue about health. But the excuse only lasts for the period of time that is within the reasonableness of what the excuse is. So if a child is really sick with laryngitis and misses a weekend, that doesn't mean that every weekend after that, when a child doesn't want to spend time with the other parent, means that, oh, well, they're not well, so they don't have to go. It's only going to be a reasonable excuse for as long as it is a reasonable excuse. I know that's repeating the words, but you'll understand what I mean, I'm absolutely sure. And remember, the balance of proof is the balance of probabilities, that it's more probable than not. That's the standard you need to reach with the judge. The other case that I have for you there is a matter of Hunter and Morrison. Again, I pulled that out because It's an example of an application, a contravention application that was actually run before Justice Tree, who's a family court judge who sits in Brisbane, Townsville and Cairns. Justice Tree is very particular about running these applications. He runs them pretty much strictly by the book, although I can tell you that when he's sitting in a registry like Cairns or Townsville, he's very conscious of the fact that he's the only judge, and if he runs a contravention, he may then disqualify himself from running a trial. So he does tend to put them at the end of the trial. That is, he hears all the evidence, and then before there's any submissions or a judgment in relation to the trial, he'll then bring the contraventions back, and he will then ask people to go through the formal process in terms of contraventions. But it's a good read, and it's one where I think you'll get a lot of information from Justice Tree. Now, I think we've got a question. Hang on.
We do have a question. It's James here, and I'm going to just read this out to you, Jennifer. Is this right? There are two limbs. One, the breach, and two, if there is an excuse. If the client takes all reasonable steps and does not themselves intentionally breach the order due to the children refusing, doesn't mean there is no breach under the first limb, but that they are relying on the second limb of reasonable excuse if it's not a safety issue.
Sorry, I may just have to read that a little bit more. Just because the kids don't want to go, that doesn't mean it's not a breach. You have, that is, the person who is subject to the order has an obligation to comply with the order. So if an order is for a specific period of time, so children have to go and visit a parent for a specific period of time, then you must do everything within your reasonable power to ensure that that takes place. If it doesn't happen, it can well be that you can be said to be breached. I don't think I could ever say that if the kids don't go, that doesn't mean it's not a breach. The question is whether in fact the court might be satisfied as to whether or not there was a reasonable excuse for not complying with the order. And it's not as simple as it's black and white when it comes to the reasonable excuse stuff. I think it's far more black and white as to whether an order's been complied with or not if the order is drafted very clearly so that there's no misunderstanding about what it's meant. And I think in terms of the fluffiness, for want of a better phrase, in terms of these applications, your best bet's running with your reasonable excuse stuff. If it's quite clear on a plain reading of the order, and go back to that case that I referred to you to of Justice Forrest, if it's very clear what the order meant, then I think a finding that it hasn't been contravened may be hard to avoid if in fact an order is clear that kids go and they don't go. The question then becomes why and whether you can use the second limb to assist your client. The next slide is the one where I give you some references to the rules, both the family law rules and the Federal Circuit Court rules for the process to be followed. It's a very clear process and it is the same process in both courts. What happens is essentially the applicant runs their application and the respondent doesn't in fact have to file material in response to establish the reasonable excuse part at the beginning. So it's not like you're running a normal application. It's a quasi-criminal application and it's a very clear process as to how it should run. And I've given you a case there of Jets and Maker of 2010, which is a fascinating read and one that I remember reading when it came out because the Federal Circuit Court judge at that time, and they're named in the order, and they're named in the reasons for judgment, heard an application, and the matter went on appeal before Justice O'Ryan in the family court. So he was sitting as a single judge dealing with the lower court's decision, and I don't think I've read a more scathing judgment in quite a long time as I did with this one. I don't think the judge in the Federal Circuit Court, in fact, I think it was he was a federal magistrate at the time, I don't think he followed one part of any process that is clearly set out in the rules, and His Honour goes to a great deal of trouble to quote lots of the transcript in terms of what was being said or done during the process, or the lack of process. And essentially what His Honour did was that he skipped the first bit. That was, he didn't really hear the contravention part of it. He only got to what's the mother's excuse for not compliance. So what happened was a battle of words, as I read it, between the judge and the counsel, or the legal representative anyway, for the mother who was on the receiving end of this application. And he went straight into, well, what are you going to tell me? What do you think is going to justify this, that she hasn't complied with the orders, essentially? And His Honour wasn't going to hear evidence from other witnesses in the matter to support the mother's mother's response that she had a reasonable excuse. What Justice O'Ryan comes down to is that he said he should have first heard the father's case, which was set out in the father's affidavit, and in respect of which there was no controversy. So the order hadn't been complied with, but he should have heard it. He should not have allowed the father to first give oral evidence dealing with the mother, or with what the mother proposed to adduce when she was required to provide a response. So he had the application, he had the father's affidavit saying there was a contravention. He then took evidence from the father as to what he believed the mother would be putting in terms of her reasonable excuse, and he made no finding that there had been a contravention before that happened. He should have done that. He should then have invited the mother to give evidence. He'd already told her, it seems on my reading of the judgment, told her legal representatives that he wasn't going to hear, it seemed from a whole lot of witnesses, busy day, busy list, not going to deal with 5 or 6 witnesses that she had, including, I think, an expert, some neighbours and various people who were able to give some information to back up what she said was the situation. He didn't want to hear any of that, it seems. And he didn't allow her to put any of those people on affidavit. She hadn't had the affidavits ready, it seems, on the day that the application was listed for hearing, but she had those people available to give evidence. So they were available not only for her legal representatives to lead the evidence, but also available for cross-examination. He wouldn't allow her to adjourn it if he was going to insist on an affidavit, which it seems as though at one point he wanted to have done. And essentially he breached her and said she had no reasonable excuse at the end of the day. She appealed and she was highly successful. So it is in fact an excellent judgment to read in terms of the procedural process. So in terms of the summary then, in terms of what happens, the applicant runs their application. The applicant gets in the witness box. They will be relying on an affidavit. You get to cross-examine the applicant, and you would put to the applicant various things to indicate that there isn't a contravention. Of course, if your client has given you instructions that they agree that there has been a contravention, that is, they're admitting that the order hasn't been complied with, the first part of that process really goes out the window, because there'll be an agreement that an order hasn't been complied with. But it's where your client doesn't agree that an order hasn't been complied with that you have to go through that first part of the application. Once there's a finding of a contravention, then it's the respondent's turn. And normally what will happen is that you will have an affidavit ready for your client, which you will then produce, and your client will then have to be made available for cross-examination. And then the other side may need to give some evidence again in relation to the reasonable excuse aspect. So it's a complicated process, and it is one that I said at the beginning of this that most people try to avoid because it does take time. One of the other things that will often happen is that judges will say if you have 7, 8, 10, 20, 30 contraventions in your application, which have to be worded very carefully, they will tell you to pick your best 5 and we'll see how we go. I don't know that I've ever had anyone necessarily run 30, even if there are 30 in the application, but I've seen the 30 in the application. So I think that process and procedure is important. The other thing I've got there is a dot point on know your judge, and we'll talk about that in a little bit. But Amy's also got some things that she wants to make some comments about.
I thought I'd just follow on then about the next bullet point with options for negotiation. Contravention, because obviously the way orders can be written occasionally, means that parties may not agree about what the intention of the orders are, and even though the judge, when they're looking at dealing with a contravention, will go to the plain meaning of the orders, it may be an opportunity for the parties, with the assistance of their solicitors, be able to negotiate new orders to reflect the circumstances, or even tighten up some orders that are currently being contravened. An example I have for this is I was partway through a trial, through a matter. Matter had been listed for trial at the end of the year, and we were having a difficulty of using a contact centre for changeover in that matter when, due to some issues with communication between the parties, the centre advised that they were no longer willing to assist the parties with facilitating changeover at that centre. The orders already had a default position in the interim orders that provided for when changeover couldn't occur at the contact centre, then it was to occur at a local McDonald's centre. In that case, the mother had some significant anxiety issues and was not willing to use the default changeover location of the contact centre for changeover, and it was in circumstances where the father was not seeing the children in that case for about a month and a half, and hence the contravention application was brought because the father wanted to enforce the order in that case. In that matter, given that there was going to be a delay in having the matter heard, and obviously a risk that the father wouldn't see the children for a number of months, the parties used that as an opportunity to negotiate them change to the orders in regards to using a further contact centre, and through the assistance of the ICL we were able to get some further negotiation. So that may be something to keep in mind, particularly if there's, as Jennifer's referred to, a 30 contravention application to be heard. The judge has made some comments that he or she only wants to hear 5 of those, give me your best, to use that as an option for negotiation, which may be the parties even agreeing to undertake a parenting orders program so they can perhaps assist each other, or get the assistance they need to understand the orders, or perhaps some make-up time, or those types of things.
Okay, one of the other dot points there that I talked about was know your judge. Now, I know that there's a docket system in the Federal Circuit Court, and most of the matters that are dealt with by way of contravention applications stay in the Federal Circuit Court. But it's important that in the preparation for your hearing, you understand what judge you're going to go before, because you have to assume that the application will be heard as a contravention on the first day that it's listed. Because they take so long to get listed, and if you're the applicant, you want it to be dealt with. If you're the respondent, you probably don't, but it may well be that it's going to be dealt with anyway. Most of the judges will hear them. Some of them, however, will be really encouraging you to go outside and try to negotiate the overall result and what the problem is. When we started this presentation, I talked about getting some instructions, getting some very clear instructions, and understanding what it is that had gone wrong, getting an understanding from your client as to what they want as an outcome, despite what the penalties may be for a contravention as set out in the Act, and I've given you on some coming slides the sections about that. It may well be that these orders just don't work, or they need to be fixed, like the 2 I gave you at the beginning of the presentation. They just are by their wording causing problems. I can say that in my own experience, one of the ones that causes everybody huge grief is the one where the children should be able to speak with the other parent at all reasonable times. that causes a huge difficulty for people, and you really need to be aware of it, and you need to make sure that if you have an opportunity not to draft such an order, that you don't draft it that way. Specific times will be so much better, even if it's, and failing any other agreement, that the telephone times happen at a certain point on certain days at certain times, and whether it's Queensland time, New South Wales time, Western Australia time, daylight saving time, make the order as specific as you can, because that's what leads people into the problems that they have. It also makes your life much easier in front of the judge if the orders are very clear. And if they're not very clear, I'd be suggesting to you that even before an application is filed, that you write to the other party or your client, that sends an email, preferably drafted by you, so that it can be produced later, to try and get the other party to talk about what it is that's gone wrong and to try and fix the orders and amend them, because you're going to spend some time on the day at court doing that anyway. You may as well have all of that having been at least attempted. Your client's going to look better in front of the judge, no matter which judge it is. But some of the judges will try to avoid some of these applications in terms of hearing them. I can guarantee it. It's certainly been my experience. Go outside. I've got a very long list. I'll see you at 5 o'clock, and you'll be there from 9:30 through to 5 o'clock, and then all of a sudden it's too long and I've got 2 other matters and this isn't going to be heard. Of course, eventually they have to be heard, because there are issues obviously about a party pursuing an application for a general proposition in terms of a matter that is an overall application, and being able to come to the court and have that pursued if they're not complying with an order. So the options, the next slide. I've given you some options for the court. The biggie, I think, is that the court can order, whether there's a contravention found or not, they can make some orders to vary the parenting orders. So the court has that power come what may. Don't, however, use a contravention application to circumnavigate a Rice and Asplund argument. They don't like that. If you want the orders changed, then you've still got to get over the hurdle of what's the significant change in circumstances that has occurred for a parenting order to enable the court to be satisfied it should be varied. So don't think you're going to get around that argument just by filing a contravention and saying to the court, oh, well, you've got the power to vary the orders anyway, whether you say there's a contravention or not. The other thing, of course, is make-up time, which I would suggest to you that you talk to your client about if they're in fact in contravention of an order and time hasn't occurred, whether make-up time has been offered or not. Again, that will look good in any information that the court receives, and the court has the power to make that as an order in any event at the end of the day. So if in fact a penalty has to be imposed, there's 2 separate areas. There's one where it's a less serious contravention and one where it's a more serious contravention, and they're defined in the Act, and I've given you the references to the sections in the slides. The things that I wanted to raise with you, though, are 9 times out of 10, I think, on a first contravention application, everyone's going off to a post-separation parenting program. The question, of course, though, is whether there should be costs. So I think the bigger issues for some clients might be bonds, whether a bond is ordered, and then, of course, there's a question of costs. Costs fall into 2 separate categories that I think your clients need to be aware of. It's not just the legal costs that are involved, but there may well have been costs incurred by the other party which have been lost because compliance with the order hasn't occurred. So what I'm talking about there is some travel expenses and some outlays that may have been incurred by a party, and then the order's not complied with, and that money is lost and can't be recovered. So you need to be aware that those expenses could also be claimed, just like time could be claimed in terms of make-up time, and your clients need to be aware of that. Of course, there's then the issue of the legal costs, which is always a fascinating argument, and I've given you a reference there of Collins and Ricardo 2016, where the judge dealt with some aspects of expenses, bond, but also legal expenses. And they're just they're good reads, and I've given you those cases so that you can have a look at what a court may or may not do in terms of those aspects. Okay. So, as a summary, in terms of what it is we wanted to make sure that we covered, can the contravention be proved? What information do we have that could be regarded as a reasonable excuse for what's occurred if a contravention has occurred? And then before it goes any further, can I generate some options to try and resolve what the problem is, to try and fix the impasse between these parties? Should there really be an application to vary the parenting orders? And that's really about taking those broader instructions from people. So the question is, why should the orders be varied? How do I get around the Rice and Aspland argument? And should, in fact, we try to negotiate through mediation? Now, I'm also conscious of the audience we have today. Legal aid isn't going to provide us with too many legal aid conferences with this sort of stuff. Their funding's become extremely tight. But it could be that RA or another mediation process may be something that people can engage with if, in fact, you've been able to open up the discussion with the other party to say, these orders really aren't working for anybody. Can we go back and see if we can fix them because they're too vague or the kids are older now and we really need to try and resolve them? Okay. I needed, just before I finish, and Amy may have some more to say in conclusion, but when you have the situation where a contravention is occurring, go back and read the rules and the sections of the Family Law Act and step through exactly each part of the process, because every time I read those sections in the context of another case, something else comes to mind for me in terms of what I need to make sure I'm able to make submissions about and what I need to have evidence about, because this is an evidence-based process. It's black and white, an order's contravened or it's not. There's a reasonable excuse and there's evidence to satisfy the court beyond on the balance of probabilities that there is a reasonable excuse, but you have to have your ducks in a row. You have to have your evidence available and you need to make sure that the judges, if you go back to that Jetson Maker case, you also need to be sure that the judge is following the process that is fair to both parties so that all of the aspects of the application are heard appropriately. And I'm going to put you on to Amy.
I just think it's important just to touch on again the importance about looking about what application you want to bring. In a few matters that I've been involved with in responding where we've got a self-represented party as the applicant, they're filing contemporaneously an application to vary the orders and an application for a contravention. In both of those cases, ultimately, the contravention was withdrawn because they ultimately wanted to vary the orders to reflect the current circumstances that were there. So I think it's just important to ensure that when the client comes in, getting some clear instructions from them about what's going on and what exactly they want to achieve, because contraventions are looking at punishing someone for not complying with the order, where it may be that looking upon the order and what's happening with the children at the moment, that it's best to look at revisiting the parenting orders to enter into some new ones. I think we've got a question, so I'll put James on to announce it.
It's quite a long question. It builds on a question that came through before, folks. So further from that previous question, is the respondent's efforts to comply, assuming they've taken all reasonable steps and are not intentionally contravening, like in Amy's example of the kids not getting on the plane or a 16-year-old voting with their feet, is that evidence that might be relevant in determining whether there's a contravention in the first place before the court goes on to determine whether the respondent has a reasonable excuse? Can the respondent file material addressing this issue at the outset before the time the court determines what it needs to look at, or whether it needs to look at that excuse? And our questioner's understanding is that a reasonable excuse only focuses on safety or not understanding the order, not the children are refusing, or is the reasonable excuse broader than protection of safety and health? So I think there's a few issues in there. Amy?
Hopefully I'll get them all. Reasonable excuse is absolutely broader than just the safety of the children. So it really, every case is going to depend on its facts. And from the cases I've run, it's really been that way. So I guess going back to the one where the children with the airport, in that case, that was actually heard over in Perth. So we had a magistrate that heard it. And he was not critical of my client at all because he had undertaken everything he's done to comply with the order. So I think looking at your example of a 16-year-old and voting with their feet, again, having your client do everything they can within reasonable means to show that they're doing everything to comply with their order. So I've read cases as well when judges have been critical of parents which have driven to change over, sat in the car, haven't facilitated or encouraged the children, sat in the car and played on their phone while the children sat in the back, stayed there for a couple of minutes and drove away. In that case, the judge had found that they had contravened the order and there wasn't a reasonable excuse. So I just using that one, I guess, to put it in context as well, that it is going to change, depend on its facts. So I think it really would be hard for me to say whether the 16-year-old would be one that would be sufficient as a reasonable excuse. I'm just double reading the order to make sure that I've answered everything in that one. We've got a second question. Perhaps I'll read it out and Jennifer can read it, answer it. I know there can be an exception to family dispute resolution if a contravention of a parenting order that was made in the past 12 months has happened and the person breaching has shown serious disregard for their obligation under the orders. What would examples be for showing a serious disregard for their obligations so that an FDR exemption can be sought?
Gosh, serious disregard. I don't have a clear example. I don't have a case for you, I should say, that tells me precisely that. I would say repeated times that a child doesn't, for any good reason, go and see another parent would clearly be an issue of serious disregard for the orders. It could well be that when you get to the stage where that sort of compliance is occurring, you may find that particularly some judges may actually call it contempt and may want to deal with it under the contempt provisions. But I'm trying to think of an order that would be of specific assistance, but I would say the easiest way I can answer it is to say repeated times when holiday time doesn't occur, when there's a great distance, like the case that Amy gave you in terms of Western Australia and Queensland, without the father trying to get the kids on the plane, make arrangements to get them to go and see their mum. If there was just nothing that was happening and it was a repeated process by a client, they would find themselves in a situation where there's an absolute serious disregard of the orders, that they're doing absolutely nothing to comply with them and they've got absolutely no intention of complying with them, and that becomes clear either from their emails or their correspondence. And no doubt people will have various parts of that correspondence presented to you. In terms of the previous question though, the question was put about whether affidavit material should be filed at the outset. I don't think there's nothing that stops you from doing that. What I'm saying though is that you don't necessarily have to. I have always said to my clients, we'll prepare the affidavit material, but it doesn't have to be filed and then given to the court days in advance like a normal application should be. I can also indicate to you, I think part of the question was so that the judge would then have an understanding. The question read to me as though someone was trying to think, would think that the judge would read all of the material before the application came before them. That ain't going to happen. The application for a contravention would be one of many on the day, and they would read what they're required to read when you tell them what you're going to read. So I don't know that there would be any prejudging of the matter. That's not to say you shouldn't be negotiating all of this stuff either prior to the application being filed or prior to the court date, because you could have the same result in trying to hit all of this on the head, which has often been the case in the matters I've had. And I think James wants to pull out some more questions for us, so I'll do that. I'll let him do that.
Terrific. quick and easy one. The slide that we've got on the screen now, Jennifer, talked about costs, must unless BI or other best interests. Thank you. So ordinarily, or the process envisages a respondent filing material. Do they always, and what happens if they don't?
Sure. So the respondent doesn't put on a defence before you get there. The application is heard to firstly satisfy the court, assuming that the respondent is not admitting the contravention. Then the first part of it is whether the court's convinced that there actually has been a contravention. Matters then usually stood down when the other party provides any material that they want to provide, or there's a list of witnesses. If they're not on affidavit, it can all be by oral evidence. The respondent would get in the box, give their evidence, and it's a bit of a drawn-out process because you're leading the evidence at that point, which is why the affidavit is far more helpful. But you don't actually have to give it to the other side until you're there on the day and the contravention finding has actually been made. In practice, though, I think most people try to negotiate, say, here's what our evidence is going to be, so that everyone is starting to think about how do we resolve it rather than how do we run it. I hope that answers your question.
Just following on for that, one matter I've had, it was more property rather than a parenting matter, but in that case I acted for the respondent. I'd prepared an affidavit which we hadn't filed but were ready to run if we need to be. But because the 3 contraventions that they alleged were so badly worded, the application was made by our counsel for the contraventions to be summarily dismissed, which they were, and costs was made for the applicant to pay the respondent's costs. So I guess I'm just raising this one whilst we've spoken today in regards to parenting matters, that costs can go both ways if the application isn't drafted properly or brought on proper merits.
Also had someone put up their hand. So Anne-Marie, are you there? Have you got a question for Amy?
Yes. Can you hear me?
We can.
Hello? Oh, good. Okay. Yeah, my name's Anne. I'm calling on behalf of St Vincent de Paul. I don't have a legal background. A lot of our clients are in difficult, estranged family situations, and there's blended families and what have you. I'm just concerned as to costs, you know, like when an order is clearly needs to be reviewed or it's been contravened, whichever the case may be. Are these people with, you know, the low income, are they covered for community legal aid in these sort of situations? Hello?
Sorry,
Hello?
I had muted myself there, Anne. The finger's being pointed at me here. Generally speaking, community legal centres won't be in a position to provide representation for people in court to run these applications, but almost or a large number of community legal centres are in a position to provide advice and support to people through this process. So to assist them in filling in the forms, to work out the strategy, and to do that important role that that Jennifer was talking about earlier around kind of sense checking and reality checking some of the expectations that they might have. So it's unlikely that they'll get representation in the courtroom for this application. There will be points through the application process where they'll be able to sit down with the lawyer and get some advice.
I guess I'm just wondering what sort of costs they face. Therefore, if they don't have any legal aid, what do they? How do they charge them court time, or do they have to have someone appear for them?
Okay.
Sorry, Anne, it's Jennifer. I misunderstood the question. That's why I flicked it to James. The Federal Circuit Court has a scale of costs. So there are some limitations around that. They're set by the rules of the court. Depending on how bad the contravention is, so maybe picking up a little bit on that serious disregard process, it could be that there was a lot of additional expense incurred, and not only are the solicitors seeking costs if the other party was legally represented, but if they've had to employ a barrister and the barrister appears and the court is satisfied that those costs are reasonable, there is provision that they can end up paying for them as well. You can be talking thousands.
The clients.
Worst case scenario.
The clients. Yeah.
Yep.
Yeah.
If the other side is
imagine, a lot of our clients.
Yeah, if the other side is privately represented, the cost could be very high. But it's
we don't see many of those clients.
Well, it might be that whilst the client who comes to you has some difficulties, the person on the other side might have a family who's prepared to stump up for a bit of money and employ some lawyers. That can happen, and I've seen it happen, and it can be very intimidating for the client that you would see. But the costs are certainly looked at by the court in a general approach. They look at it very carefully, but it can go into a lot of money.
Yeah, so it's really important to get that order bang on in the beginning, as you were saying earlier.
That's why we kept talking about it at the beginning, because I think that's where a lot of the problems start. The orders on a busy day, at the end of a long day of mediation, or the end of half a day of a legal aid conference, when there isn't enough time to draft some orders really well, it might well be that that's where our problems start.
Okay, thank you.
I might start to wrap things up. So can I, on behalf of everyone who's tuned in at computer screens across Australia, really, and are now clapping and cheering wildly for what was a really engaging and relevant presentation for community lawyers and our friends, thank both Jen and Amy for, as I said, thoughtful, interesting, engaging, and incredibly relevant for a lot of the work that we do. As many of you will know, about 40% of the work that's happening in community legal centres across Queensland is family law work, and so you guys are seeing this stuff all the time, so it's great to be able to draw on the expertise. We're seeing some really great messages of thanks coming through from you too. Thanks to everyone that participated this morning. What a way to start Hump Day. We will look forward to catching up with you soon. Thanks everyone, and goodbye.